So, welcome to this week's episode of Crap No One Tells You. With me this week is Mike Terkanian from Terkanian Law, a business attorney who has some interesting background as well. But welcome, Mike.
Hey, Gavin, good to see you. It's great to be here. We talked about doing this for a little while ago, so yeah, here I am. It's awesome to be here again.
So let me start with a basic question.
Yeah,
What is some crap no one tells you about starting a business from a legal perspective?
starting a legal business or starting a business?
Starting a from a legal
perspective.
perspective.
Number one, I would say, so a little bit of background. So I work with a lot of startups, like people that are literally have never had a business before and are just starting their
Mhm.
business. They have, most of the time, they have no idea how much work is going to go into getting that business off the ground. A lot of times now some of them most of them are smart enough to realize this, but sometimes I do get people that come in that do the build it and they will come and it obviously it just isn't like that, right? Otherwise, what's the need for marketing types like yourself, right? So that's one of the big things that people have a problem with is they seem to think, well, I'm going to start this business. I'll get customers, I'll get money, and I'll be able to support myself. And in about 5 to 7 years, that may very well be true. But right away, absolutely not. It's going to take a long time to build up the relationships, clients, et cetera, et cetera. Now that's a finance and marketing issue. From a legal standpoint, I would have to say first regulatory, not regulatory, but compliance, making sure that you fill out, you either form your LLC or your corporation or whatever you're going to do first, right? And do it properly. We had a client just last week that has been running a business for over 15 years who didn't realize he didn't actually have a corporation. He had sent a check into what he filed it himself 15, 17 years ago. I can't remember the exact date. Sent a check in. The check wasn't NSF, not sufficient funds, so it bounced, and the corporation was never actually formed. But it was listed in the register as revoked. So when he'd go and search the corporation, it was listed there, but it was always listed as revoked. And what that meant is if he were ever to have been sued or something like that, there's no corporation to sue.
It would have been him.
It would have been him personally. So he thought, oh, hey, it's all good. I'm a corporation, but you're actually not. So it was a big mess, but we're getting him out of it. But that's number one is compliance, making sure you register properly. And then number two, I would say, and this is across the board, please don't download contracts from the internet and think you're okay, because you're not.
No, I had someone send me a contract once that had a different company name in it, and I was like, I guess he Googled that one.
Right. Exactly. I have seen that. I have seen other people's names, different companies. We had a contract once where it was, let's just say it was for the sale of a pizza place. It wasn't, it was something else. And it talked about making sure that the accounting firm used GAAP in the transition. It's like it was a contract for an accounting,
Right.
for an accounting firm being sold. It was just the craziest thing. Someone had downloaded it and just, changed names and thought that was enough. And there's so much more that goes into it.
So, one thing that you said once that I didn't realize is when I form my LLC, when I form my business,
Yep.
I should technically not speak to any vendors or customers before the LLC is officially filed.
Yes. So what happens is okay, I'm going to talk about Pennsylvania right now. Okay. So in Pennsylvania, if on July 21st, right? So on July 21st today, I go and I file my paperwork with Pennsylvania for the LLC. Assuming everything goes through, there's no name conflicts or anything like that. I might get it back in, they're doing better now, like maybe 3 weeks, 4 weeks now. It will be stamped as of July 21st. So we're good. Okay.
Okay.
But if there were an issue with the name and I had to change the name or do something else, it'll be stamped as the time I register it the second time. Okay.
Okay.
So it might be 4 weeks before I find out that there's a problem. And then I have to re-register. And now that registration date would be sometime in August, sometime late August.
So anything you do from the first date till the second date is technically on you. There's no
Right.
corporate
So
entity.
what happens is if you're doing something in anticipation of a business being formed, an entity, let's say being formed like an LLC or a corporation, you are known as a promoter of that business. Okay. And depending on what you do, you may actually be on the hook for anything that you sign in the name of the business prior to the business actually being formed. So let me give you my July 21st example again. If you sign a document on July 28th, okay, after you formed it or you submitted the paperwork on July 21st and July 28th, you signed a lease, for example, in the name of the business, and everything goes through properly, you're probably okay. Good luck. You got lucky, right? Because I have seen plenty of things come back and say, no, you can't use this for various reasons. But let's say you sign that lease on the 28th and the LLC doesn't go through. And for whatever reason, PA kicks it back to you and says, no, you can't use this name. Then you have to file all over again. But you don't find out until the middle of August. And then you file August 21st. That lease is technically and actually legally on you as an individual, not on the company, because the company didn't exist on July 28th when you signed it. So you as a promoter have been going out and signing things in the name of a business that doesn't exist. What you're supposed to do is while you're waiting for the paperwork to come back, is you're supposed to go around and negotiate. What will the lease look like? What will this vendor contract? What will the manufacturing look like for our product? Get all your ducks in a row. And then once the document comes back from the state,
You can then start
signing away and go crazy. Okay. So that's where you need to be careful.
So it's patience.
It's patience. Exactly.
Prep, understanding
right.
what you're personally versus the company.
That's exactly right. Yeah.
Another thing that I ran into, well, not ran into, we run into it multiple times. Someone files their LLC name and then they come back to us and they're like, I want you to make a logo with this. And let's just say it's Frank's Automotive.
Okay.
And we go, but there's 22 other Frank Automotives. And they're like, yeah, no, but I was allowed to register it so I can use it. You can use it as what? Can you use it as a legal name? Yes.
Right.
Does that mean that we're allowed to create a logo called Frank's Automotive and start putting you out there?
Right. So now you're getting into branding issues.
Right. You're getting into trademarks and registration and
trademark. Exactly.
And a lot of people don't understand that just because you can file an LLC doesn't mean you own any type of rights to that name when it comes to branding and marketing it.
Okay, so there's a couple of different, there's actually quite, believe it or not, that little bit, there's a lot to unpack there. So we'll go through some of it in a little bit. So when you file the name for an LLC or a corporation, if no one, now some people will file a DBA, right? And they'll think that that's protection. A DBA is not protection whatsoever. Okay, it gives you absolutely no protection. But when you file an LLC or a corporation, it prevents anybody else from using that exact name in that state. So Pennsylvania, for example, from Frank's Automotive. Nobody else could file for Frank's Automotive LLC once I register it. Okay. But again, it's just creating the company name. It doesn't mean that I can go and start using it as a trademark, but we'll get to that in a second. What it doesn't prevent is someone from creating Frank's Automotive and Sales LLC.
Right.
That can be created. Frank's Automotive Repair LLC. That can be created because it's not the exact name. Now, if someone were to try to file Frank's Automotives, I don't know what you would, but if someone tried to file Frank's Automotives, that would probably get rejected because it's just one letter off. It's not going to work, right? But Frank Automotive Repair, that would get registered. That wouldn't be a problem because the state's not looking to protect your brand. That's not what they're there for. They're just there for saying, okay, you want a business? Here's what it's going to be called. We just have to make sure there's no one else using that name.
Right.
Okay. So that's the registration side. Now you're talking about trademark. So there's two types of trademarks. There's your common law trademark and then there's your federally registered trademark. Okay.
Right.
Common law trademark is, okay, we'll use Red Knight. Okay. We'll use this guy, right? Red Knight. Okay. I go out, you go out, you start your company, you open up a store, you have your name, you have your logo. You are protected with common law trademark from anybody else using that name or logo in your general area. Okay. So we're here.
So what do they define as a general?
Well, it depends, right? It depends on where
we're sitting what? 15 miles from the Jersey state line.
Right. 25 miles from Philadelphia.
Right. So would it be protected in Philadelphia, but not in Jersey?
So it would depend on where your market reaches. Okay. And a lot of it comes down to if like someone, if there were to be a lawsuit, it might come down to market research. If someone were to go across the bridge into New Jersey, what's that town? Not Lawrenceville, Lambertville, New Jersey, right? Across New Hope. And you can reasonably expect for somebody over there to recognize your brand, then yes. Then yeah, that would be protected in that area, not in all of Jersey, but that particular area. But if you're just starting out and you're a few weeks old, no one in Lambertville's going to know who you are, right?
Nobody up the street.
Well, they might because they drive up.
Well, yeah,
they might see your sign, etc. Right? So anyway, so and this is why common law trademark protection isn't the best, because of that exact question. What's considered in the area, right? It really comes down to a lot of things: how long you've been around, how wide your reach is, things like that, right? So common law trademarks, while again it's a protected class, it is very difficult to enforce if someone is right next door to you. If they're next door to you, yeah, obviously.
Right.
But if they're 20 miles away, who's to say your reach isn't that far, right? Now, federal trademark is when you register with the USPTO, United States Patent and Trademark Office, and that's it's a trademark that once it's approved, you are protected throughout the country. Nobody else can use your trademark or anything that's considered confusingly similar.
Right.
Okay. So, for example, Red Knight, right, for marketing purposes. Now, I could open up a company called Red Knight and register it with the USPTO for automobile repair because it's in a completely different class.
Clothing,
right,
or something else. Yeah.
Right. But I couldn't. Now, you spell Red Knight REDKNIGHT, right? I couldn't open up Red Space Knight NITE or something like that and put that in marketing services.
Right.
I couldn't open up. It would probably be difficult for me to open up like Yellow Knight too. That might be tough. The USPTO might not allow that because when you get a word, that word's going to be screened. When the USPTO is examining a trademark, they scrutinize every single word, right? So they say that the word red, they might look for other primary colors too: blue, green, yellow, orange, and they might say, you know what? It's too confusing for the general public for us to allow this to be used, because we don't want someone to think that they're buying from you and they're actually buying from somebody else.
So like if I own Blue Mountain Sports and someone tried to file White Mountain Sports,
right,
they would probably have
They would have a problem with that, right? And it also has to do with a lot of times how long you've been around, what your market reach is too. Because let's take, for example, Blue Mountain Sports, right? Let's say Eastern Mountain Sports. Okay, they're known throughout the country. Everyone knows Eastern Mountain Sports, right? Anyone that does any kind of outdoor activity knows Eastern Mountain Sports. This is not a plug for Eastern Mountain Sports. But everyone knows them. I couldn't make Western Mountain Sports, Northern Mountain Sports, because they're well too known. Everyone knows who they are, right? But if they were a brand new company and their name wasn't as well known and everyone didn't know them, then there might be a good argument. You know what? Eastern Mountain Sports is up here in the east side. I'm starting Western Mountain Sports out in the California area, and there actually might be some argument for that. Okay. But it really has to do with how well known your brand is.
So when you're registering a trademark, whoever at the patent office looks at it, it's partially subjective too.
Yes,
they have to
evaluate. Trademark office,
right? Sorry,
they're very different things.
I'm sorry. So the trademark office is someone has to look at it partially subjectively and go, but this is a national brand, or they have to look at it and go, they're only functioning in one state. So, and this is not with an exact match. This is with like likeness, right?
So when you're filing your trademark, you can actually make that case. Okay, so here's let's go through the life cycle of a trademark file. Okay? You go and you file your trademark. You're supposed to do your research first, make sure, and that's what we do. We do research to make sure as best we can. And then when you're reasonably confident that you could file it, you file it with the USPTO. Then you wait 6 months, a year. It all depends on how long they take. And then they come back to you and they might say, no, you can't use this because of X, Y, and Z. At that point, you can file what's known as an office action. And that's where you would go and say, but we're this well-known brand that had been around for a while and have been doing X, Y, and Z.
Right.
You're probably already trademarked at that point, but let's just assume the hypothetical here. That's where you would make your case that you're a well-known brand. For whatever reason, you just never trademarked it. And we have stores throughout the country, et cetera, et cetera. Then that would give the examiner a reasonable information to go back and have an opportunity to re-examine it under that light, if that makes sense.
Yes.
The thing is, by the time you're a well-known brand, you probably already have a trademark.
You should.
Right.
I mean, I tell people in your first year in business, register for at least one category.
Yeah.
You don't have to register for 5 or 10, but register for one category because it's protection that you can't really retroactively function or retroactively get.
Right.
It's very hard to do. So you're better off spending a couple $100. Just register it and we're good to go.
Here's a great story. I do apologize. I don't remember if the guy trademarked it or not, but Microsoft created Internet Explorer many years ago.
Mm-hmm.
There was a gentleman who had created a web browser called Internet Explorer about 5 or 6 years before Microsoft. And I believe he trademarked it, but no one researched it. No one found this Internet Explorer. No one used it. No one, who's this guy, right? Versus Microsoft. So no one actually used his browser.
Didn't Meta just do the same?
Oh yeah. Yeah. we'll see how that lawsuit turns out.
But
that's even crazier because we're talking back in the 90s, right? Where it's not nearly as much information.
The USPTO wasn't on high. You
had to actually go down to the offices and research in books, and it took forever. Now it's a Google search, and you can find it. Yeah, the meta stories. I'm very interested in see how that one works out.
I am as
well. So Microsoft actually, violated his trademark. I forget how much money they had to pay him, but he was holding out for a while because he knew he was right. It was his trademark.
Oh, yeah. And people don't realize, I think, how many trademarks are actually registered. Like, I didn't realize there was some guy that apparently registered $1 Million Mindset as a trademark.
Yeah.
And I was like, I didn't even know that you could register it.
Right.
Yeah, no, he just went and he had been using it in some of his material and trademarked it. And all of a sudden you stopped seeing everybody using $1 Million Mindset because there was a guy that now owns it apparently.
I believe it's a trademark. Let's Get Ready to Rumble.
Yeah.
Right.
The announcer. Yeah.
Right. Michael.
Forget what his name is.
Yeah.
Buffer.
Michael Buffer. Yes. He has Let's Get Ready to Rumble trademark. I believe it's not copyrighted. I believe it's trademarks.
Yep.
And he's the only one who's allowed to say it.
Yep.
And that's why he's the only one doing it.
If you see it on a t-shirt, chances are he's getting a few pennies up
right. Yeah. So you can have things like that are trademarked. But I want to stress something. People ask me this all the time. And I ask people this all the time too. I say, well, actually, I'll ask you. You're more into this field, so you probably know. What is the purpose of a trademark?
To protect my identity.
No. You don't know. Okay, I don't. Yeah. So a lot of people think that. A lot of people think it's for no one else uses the company's name to protect the company, but that's not true. It's actually to protect the consumer from making a mistake and purchasing from the wrong company.
So trademarks were designed around the consumer, not around the business.
Correct. Their real purpose is to protect the consumer from making a mistake and purchasing from a company that they're not familiar with. So, Tide detergents, right? I know it's again, not a flip for Tide. I know it's a good clean.
It's hard to talk about brand names without brand names.
It's a good clean, laundry detergent that I have no problem with. If someone were to come up with something like TED or something like that, it's too confusingly similar. Right. Or if the logos are the same, and I might buy the wrong detergent, now my clothes are ruined.
And one thing that I learned that I didn't realize, for example, Ryobi tools.
Yes.
The color of the Ryobi tools.
Like greenish.
Yeah, whatever. Not a plug for Ryobi. But that color on those tools and how they use it apparently is also protected, right? Like,
yes,
I didn't know you could do that, to be honest with you.
Kodak did that. Kodak has at least one color in the Pantone and all the colors in the world that is they own the rights to. No one else is allowed to use that color. I think it's some type of orangey yellow. I forget exactly what the color is, but Kodak owns the rights to that color, and no one else is allowed to use it commercially without their permission.
It's interesting.
Yeah.
Are there other things I can register about this subject?
I forget how they got that because it's so weird. So, the one that I still don't understand is Ohio University.
Okay.
They have trademarked or the, as they say it there, have you ever watched college football?
Yeah.
Okay. So whenever, not college football, I'm sorry, professional football,
Yeah.
when it was from Ohio in the beginning, usually on Monday Night Football or something like that, they'll have each player. So I was with
Ohio University from Alabama.
Right, from the Ohio University, or sometimes they just say the,
right.
And that means Ohio University. Well, they were able to convince the trademark office that the in the field of college football means Ohio University.
Wow.
Is that crazy?
That's insane.
Yeah. But it makes sense, but it kind of, I don't know. It's just the word the.
Yeah.
How do you trademark that? But it makes sense too, because you watch Monday Night Football and anyone says the, they're from Ohio State University.
Right. That's interesting.
Yeah.
Fascinating. So, want to switch gears a little bit?
Yeah, sure.
You and I sometimes play my favorite game called How Can They Sue Me?
Yes.
Which my insurance agent doesn't find as amusing.
No?
Yeah, when I go back to him and I'm like, so. But one of the things that people don't realize when they're putting together a contract, once again, the reason you don't go find something that doesn't work, I'm not saying you shouldn't look at other contracts, but you should never copy a contract, right? You want to get ideas and like, you're getting an idea of how someone can sue you basically by reading someone else's contract, because they may have thought of something you didn't.
Yes. That's true to a point, but we'll get to that.
Yeah. But so when someone is starting their business, you should have a contract for almost everything that you do, right? Especially if you're a service business.
Absolutely. Oh, yeah.
100% you should have it. So what are some things, of course, other than having the direct conversation with an attorney right away, which is the smart move, what are some things people need to be aware of? Like, why do you need a contract? Where does it protect you and where does it protect the consumer?
Okay.
I know that's a big question.
Yeah. So again, a lot on the gravel there, right? So it depends on the type of contract you're talking about. Okay. So let's talk about a contract between you and your customer. So the service. So let's say you're a service and based business as the contract between you and your customer. Okay. When you're drafting the contract, yes, you want to take your customer into consideration to a point, but quite frankly, you're drafting it to protect your business. You're not drafting it to protect your customer. Okay. If your customer wants something added to the contract down the line, let them tell you about that. At the end of the day, your contract is to protect your business, not necessarily to protect the customer. I'm not saying forget about the customer, the heck with them.
Right.
I am saying that if there are things in the contract that can conflict, do it to your advantage.
Right.
It's best for you.
Err on your side.
Err on your side. Exactly. And so things that need to go into it. Number one is expectations. Okay. So if you don't have reasonable expectations set out in a contract, for example, timelines, money, right? Overcharges, change orders, things like this. Your business change orders are all over the place.
Very common with contractors too.
Right. Contractors have change orders all the time.
They started building a house a year ago and now a piece of plywood went from $40 to $80.
Right. Exactly. Or this has happened recently a lot. New zoning ordinances come in and now that 16-foot buffer that they had is now actually 20 feet.
Right.
That changes the entire layout. And then you have to go through zoning issues that costs money. All right. So all those things that you can't account for them. You can't think of all those things. So you have to have in your contract, the expectation that, look, if things change, if there's more money involved, if there's, if you as the customer want something different, right?
Right.
Now you want a spiral staircase.
Yeah.
That all has to be.
I thought this was supposed to be Trex, not
right.
what,
Exactly. Yeah, exactly. That stuff needs to be accounted for. So again, while you can't think of everything, and you would have to make sure that your contract at least addresses if there's a change. What do we do? right? So it's got to be flexible. It can't be rigid. If it's a rigid contract and you're the provider, you're going to be out of luck. You could find yourself in a deep hole. Secondly is,
So sometimes closing every loophole isn't to your benefit. So
that's right. You want to leave it open sometimes, right? Because at the end of the day, a contract is something that gets interpreted if there's ever a dispute. It's got to get interpreted by somebody. Secondly, be careful of, and I've seen the service provider put this in a contract, not realizing what it is. I'll tell you what it is in a second. And they think that it's going to entice the client to sign, and that, oh yeah, well, we're doing you a favor, but we're telling you how long it's going to take. They use the term time is of the essence. Okay. That is a legal term. That means if I tell you July 1st, it must be completed by July 1st. And if it's not, I have breached the contract. And sometimes I've seen contractors put that into their agreements because they think what they're telling the client is, yeah, we're going to try to have this done by July 1st. We understand it's important to you, yada, 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 but they don't realize that they've locked themselves into that date.
right.
So be careful. Again, there's certain things that you might grab from a contract off the street, not realizing that it has such a, because it's holding you to so much.
It seems like such an innocent term. Like, yes, we're going to do this as quickly as possible.
Exactly.
We understand it's, yeah. And then you basically screwed yourself.
Exactly.
Like,
right.
it's,
I would say another thing is indemnification, which most people don't realize what it is, but it's so important. Okay. Indemnification is where, if I'm providing because you're a marketing company, you provide a service to me. Okay. And I give you all this material to, okay, here's a great one. You create a website for us.
Right.
Okay. As part of your service. And I give you all this material, pictures, videos, etc.
Everything.
Right. And you go and you put them up on our website. You may not, or probably don't know necessarily where all that material came from. Well, I could have just downloaded it from Google Images and gave it to you, right?
It happens when
you think. Yeah, exactly. And that material is actually owned by iStock Photo or something like that, or Getty Images.
Then you get a bill,
And then
Getty Images.
Exactly. And you get 50 grand saying, hey, you stole our intellectual property. Well, you're the one who put it up. So you could be on the hook. Even though it's our website, you could be on the hook too for being the one putting it up. So what indemnification does is it says, look, if I'm going to give you something to use to my benefit, you're not going to be held responsible. If anyone comes after you, I will take the brunt of it. I will pay for the defense. I will pay whatever fees are involved, et cetera. Right. That's a very important thing to have in a contract, is indemnification.
Especially if you're getting something from a customer.
Right.
Like if they're providing it, you have no idea. Because I'm just thinking this could be, you buy, owner shows up with lumber.
Right.
Where'd you get it?
Yeah.
A buddy of mine.
Yeah. Fell for truck.
Like contractor uses it, and now all of a sudden it's,
Yeah.
Did someone show up with a pallet of lumber or, a truck of lumber? And they're like, yeah.
Yeah. And I always recommend mutual indemnification, by the way. I see contracts come out that are one-sided indemnifying. I always recommend mutual indemnification. Just because we want to make sure that it doesn't work the other way. Like, you could go and steal images off Google Images, and now I'm in trouble.
Yes.
Right. So, those are some of the things. I mean, there's a lot to it that we could go spend hours just on contracts.
We could probably do 6 episodes.
Yeah. Just on contracts. Right. So there's a lot that goes into, making sure you have certain things in your contracts. But at the end of the day, what a contract really is, it's an agreement that says, I'm going to do this for you. You're going to do this for me. Right. And that's really all it is. And then all the other stuff is if it doesn't work out. Right. Really.
And that's really what it is. That's what the contract is. Majority of a contract is generally something goes wrong. Because if everything goes flawlessly, you never have to pull it out.
That's correct.
So it's interesting, because I remember when I first came to the US, we were doing website development only at the time. And I took my contract from my home country, and it was literally 5 lines.
Okay.
Right. It fit on the quote form. Like, that's how long our contract was there.
Okay.
So I took it to an attorney here, and I'm like, okay, I need a contract that basically says everything that these 5 lines are implying.
Right.
Right. Because law works differently. where I'm from. I got back a 2-page font size 8 document that basically said, in order to protect you from all these things that it took 5 lines,
Right.
I now have like this massive contract.
Because you didn't realize you're in the most litigious word country in the world.
Right.
Yeah.
And it's funny because the insurance guy that was on, and he's like, well, why wouldn't you get insurance for that? He's like, if someone sues you and you have to spend 20 grand defending it and you win the case, do you really feel like you won?
Yeah, you still lost 20.
You're still always 20 grand, right? And I'm like, this is where understanding contracts and insurance and all that stuff is so important. And I think that's one of the things many startup business owners overlook. And like, we have a ton of startups that come through our doors, right? And I always go, well, and they go, well, this is what I want to do. And I'm like, are you aware of the liability you have with that? Do you have a contract in place that protects you from that liability? And they go, what do you mean? And I'm like, what if you give someone bad advice?
Yeah.
Well, I'm not going to give someone bad advice.
Oh, really?
Right. Right. According to you or them.
Right.
Right. Like, so it's very interesting to see, the evolution of a business when they first start out and then you get burned once. And now all of a sudden it's like whole new ball game. Right.
And it's funny that you say the evolution of the business, because I tell people quite often, a lot of times a contract, especially for companies that have been around for a while, a contract will be a partial history of that business.
Right.
Because something will happen inevitably along the way.
Yep.
And now they have to account for it specifically in the contract.
Yep.
I see it happen all the time where I'll read a contract from someone else. The company's been around for 20 years. And it's like, oh, wow, that must have happened to them because now they
otherwise like that do not use in shower.
Right.
Yeah. You're like,
exactly. Yeah.
someone must have actually done that in order for them to put that.
We like these disclaimers all the time on products. It's like, who did that?
Right.
Why would somebody do that?
So to wrap things up.
Yeah.
If someone is looking at starting a business today,
Yes.
other than calling the attorney just to say hi,
Yes.
what are like the top 3 things they should do before they start or during the startup process?
Are we talking from a legal standpoint?
From a legal
Okay, purely from a legal standpoint. Number one, make sure.
Because as a marketing guy, I'll tell you.
Yeah,
we're completely
sorry. Well, that's why I wanted to make sure we're saying in my words.
Yes.
Number one, make sure your name is available, right? Make sure that you're not going to be put in a position where you create a company with a particular name that winds up becoming an issue for you later on because now you've infringed on somebody else's copyright or or somebody else's trademark. Because what'll happen is you'll make your cups, you'll make your business cards, you'll make your flyers, you'll make all these things, you'll spend $50,000 on branding and t-shirts. And then someone says, cease and desist, stop using my name.
Which we just saw happen locally to our restaurant.
Okay, there you go. See, so number one, make sure the name is available to use. Number two, I would say is figure out once you figure out who your clients are from a marketing standpoint or who your market is, then you want to have contracts ready. Okay. I don't care if you're selling a service, absolutely need to have a service-based contract. If you're a restaurant, obviously you're going to have people signing, having meal, but you will have vendors that will provide you with food and such. You're going to need to review those contracts or have contracts ready to give to them, because what happens if the veal is bad and someone gets sick? Indemnification, right? You want to make sure you have those things created and lined up so that you don't fall on your face down the line, so to speak. And then I think the third thing would be to, let's see, you have your name, you have your contracts.
So when you say you have the name, I'm assuming we're going to tell them to register the trademark at the same time for at least one cat.
Oh, absolutely.
Okay.
Yeah.
I don't want anybody to
I'm just
skip that step.
I'm assuming you've done your research, your name is good to go. You've registered it with the state, you've registered it with the USPTO, you're good. You have your contracts lined up for whatever you need. And especially if you have employees, by the way, which absolutely do a segment just on employees, because wow.
We have an entire HR series.
Okay, good. Bring me back for that.
Yes.
And then the third thing I would say is to just keep on top of the laws regarding what you're doing. And here's what I mean by that. And this is if you're not going to initially contact an attorney, which you really should. I'm not just plugging.
I know.
I really should contact an attorney, but stay on top of
Someone in Washington State listening to this is probably not going to call you.
Exactly.
Right.
So, here's what I mean by stay on top of the laws and the rules. You have federal rules, right? Federal regulations, EPA, SEC, FDA, depending on what you're into, what your business is. There are thousands, millions even, not maybe millions, but thousands and thousands of rules that you have to worry about. Not everybody knows what they are. Not every attorney knows what they are. Okay. But our job is to go and research those rules, see how they impact you. Well, after the federal rules, you have your state rules, right? Your state's going to have specific rules that and it changes from state to state. So if you're in multiple states, you have to worry about the rules, how they might change from Pennsylvania and New Jersey. How do they guys apply?
If you're like us, we're 10 miles from the state.
Right, exactly.
So it's not uncommon that someone calls us from a different state.
That's right. And then you also have your local rules, right? You'll have your township is going to have certain rules on what you can and can't do. It all depends on your business. If you're a contractor, right, you probably won't have as much federal rules as you will state and local rules. Your local rules are going to be the biggest thing, right? Permits, zoning, et cetera. That's primarily local. However, the federal would come into play because maybe you're building on wetlands, right, that are federally protected that you're not aware of, right? So you really need to research the rules of your business in the area you're going to be at. And it's difficult to do if you don't have the experience as an attorney. So that's why, again, if you're not going to hire an attorney initially, you're going to spend a lot of time researching rules to make sure, because I don't want to see people just go and open up shop without knowing that, hey, here are the rules for it. Here's a really good example. Okay. And it has to do with signage, but here's the example. Client bought a business that was a pizza shop, right? And she bought this business. Well, this lady really love her, but she gets herself into all these kinds of weird scenarios. That's not her fault, but she bought a pizza shop, and the township, a month after she bought the pizza shop, changed the sign rules in the township. Mm-hmm. You're allowed one sign outside of your building. The guy who owned the pizza shop before had signs up and down the street, right? But they changed the rules. She didn't know they changed the rules. You know, she found out when she got a fine from the township saying, you're only allowed one sign. You had 10 signs out there, which were from before, but she didn't know. She didn't know that the rule actually changed a year before, but just went into effect after she bought it. Now, this guy probably didn't know either, sold it to her, but an attorney probably would have found that out.
Right.
So it's things like that. So that's why, you know, staying on top of your local rules and such are really important thing.
Okay. Well, thanks, Mike, for coming in.
Absolutely, man.
And we will be back next week with another episode.